I'm Tom Goldstein. I'm the publisher of SCOTUSblog. I'm a Washington lawyer. I have a law firm called Goldstein and Russell. I teach Supreme Court litigation at Stanford and Harvard law schools. Our focus is almost exclusively on Supreme Court litigation. We represent the parties in about 1 out of every 10 Supreme Court cases through either the law firm or the clinics that we have at the law schools. And so we do arguments on the merits, and we do lots of cert petitions, briefs in opposition, amicus briefs. We're just very focused on that one place. The clinics at Stanford and Harvard are an outgrowth of the law firm's pro bono practice. So when I first started in Supreme Court litigation, I was mostly doing cases for free, pro bono cases, to try and build up experience. And so I had a whole collection of that work, and my thinking was, who is it that would be really interested in contributing their time and effort to pro bono work? And I just thought, well, law students would be perfect for this. I had actually gotten my best experience as a law student as an unpaid intern for Nina Totenberg, and that's how I got interested in Supreme Court work. And I thought that law students would have a similar reaction. I also thought that as someone who had gone to American University's law school rather than one of the nation's elite law schools, and it was a fantastic school for me, I really thought that this was work that law students could do if they were really committed to it and had the time to do it and had the right supervision. It's not something that only someone who clerked for the Supreme Court and worked in the Solicitor General's office could do. They are at elite universities. There are great opportunities for us to work with really talented law students, and having the affiliation with law schools has been tremendous for the law practice too. So we definitely try and get a really talented group of people involved in the cases. But I think we could do the clinics at other law schools as well, and there are clinics at Texas and at UVA and at Northwestern in addition to Yale, and so a lot of schools have recognized the value of these sorts of programs. Sure. The law students at Stanford and Harvard really are completely committed to the effort. The great thing about those programs is when they're running, the law students work on the cases essentially full time. They are not part of a broader curriculum in that semester or that quarter at Stanford. They have almost no other classes to no classes at all. So at Stanford, if you're not an advanced student, you're not doing it for the second time, you're really not going to have any other coursework other than your work on the clinic. And at Harvard, we do it in the winter term, which is a 3-week program, and the students actually move to Washington, D.C. to work with us in our offices on the cases. So I think that's really important to have that complete and utter devotion to the cases so that you can really kind of absorb yourself in them. The commitment from the law schools is tremendous to allow the students to spend that much time on the work. And it's also not cheap because the students for Harvard, they move to Washington. For Stanford, they go frequently to visit the clients. They come to Washington to see oral arguments and meet people. So it's an expensive program for the schools. I think that to do this job well, you've got to have some good writing skills, you've got to have really solid analytical skills, and you've just got to be able to separate yourself from a lot of the facts and emotions in the cases. You really have to believe and advocate for your client, for sure, but it's very different from being a trial lawyer. The Supreme Court in particular, the courts of appeals, generally are going to be concerned about getting the law right rather than producing justice in an individual case. Litigating at the Supreme Court at a high level also involves a lot of understanding that group of 9 people and what it is they're trying to do at different stages when they're agreeing to hear cases, when they're deciding cases on the merits, understanding the value of the briefing versus the oral argument and the different role that those play. As I've been doing this now for 15 years, almost entirely, that's been my overwhelming focus. It gets actually more and more complicated, not simpler and simpler, as you realize all the different layers to the onion that you're peeling back. Almost. I had, as having been Nina Totenberg's intern at NPR, kind of fallen in love with the Supreme Court. I clerked for a year for here in D.C., and then went to a big law firm, Jones Day, which was tremendous for me, and had an appellate practice and a Supreme Court practice, and I got introduced to the actual legal practice there. And then I went to a firm called Boyce Schiller for a couple of years, which was just starting out, and they let me do some of this work. But by the time I got to my fourth year in practice, I just went out on my own and decided I'm gonna try and accomplish this myself. And so ever since 1998, 1999, I've been doing this almost exclusively. SCOTUSblog has been around for 10 years. It, like the clinics, is an outgrowth of the practice. We started it, my wife Amy and I, who practices with me, as actually an advertising tool for the practice. The original model for SCOTUSblog was, we'll write about the highest profile Supreme Court cases. We'll also write a lot about what we're doing, and people, as a consequence, will want to hire us to do Supreme Court work. Turns out to be totally untrue. It is not an effective business development tool in that kind of direct way. It is in there are other ways that blogging in other kinds of practices can be. If you wanted to be a practitioner in a particular court of appeals or state Supreme Court, or if you wanted to do a particular kind of immigration or patent work, you could develop a kind of expertise that you would express through blogging that I think really could get you business. But in Supreme Court litigation, there's so many people who have such well-developed reputations. When you talk about Paul Clement and Carter Phillips and Seth Waxman and Maureen Mahoney and other folks like that, people tend not to say, I want the guy with the website, right? That's not what they're making their decisions based on. It's certainly the case that we become best known for the blog. As the blog has evolved, within about 4 or 5 of the 10 years, it really turned into a journalistic effort. And then all of the things that we were doing to try and advertise the law firm all were cast aside. And it went in the opposite direction, because we really needed our readers to view us objectively and have them not believe that we were trying to kind of show off ourselves or highlight our own cases or clients. And we became sufficiently influential with respect to the court itself that we didn't want the justices and their law clerks to believe that we were trying to influence them in our cases. So we now have these policies that where I predict cases that will be granted, we always exclude our own cases. We don't write about our own cases. We get other people to write about them for us. We used to highlight briefs that we filed. We never do that anymore, where people of ours would get clerkships, all kinds of things to try and draw attention to ourselves. That's all now actually forbidden in the blog, so that we can retain its journalistic objectivity. It generally works pretty well because the blog doesn't do a huge amount of commentary. It's not, this Supreme Court decision was the greatest or the most horrible. It's describing what happened rather than evaluating what happened. So we don't find ourselves in a lot of dilemmas of not wanting to criticize the court or things like that. And if we do want to criticize the court, then we just do it. Although a lot of times we think the court does great work, and we sometimes say that too. And our commentary is generally done by third parties. We have these symposia, for example, on all the major subject matters: healthcare, Arizona immigration, coming next term, the Kia Bell case on corporate human rights violations, gay marriage, the Voting Rights Act, and hopefully the court is able to distinguish whatever those people say on the blog from what we might say as lawyers. It has been an extraordinary evolution for the blog, particularly as the amount of reliance and respect for the blog has grown. When the blog started in the early days of blogging, blogs were really regarded as kind of oddball things. And now you see a fair amount of respect for blogs that really show over the course of several years a level of expertise and balance. They get cited a lot in the traditional media. We get, a lot of people are saying very nice and kind things about us and rely on us. I'm not sure what the next major development for the blog is. Or for the past couple of years, the structure of the blog has been the same. That is, we adapted to the fact that people were relying on the blog essentially for two different kinds of things. One was, daily updates on what's going on, reports on oral arguments, and another was an archival research feature where they could get all of the briefs and could study the cases. And so we adapted the underlying architecture of the blog to accommodate that. We have case pages for all of the cases now. There's not and so I could see the path to this point. I haven't, in my thinking about the design of the blog, imagined the next big thing. I suppose it's likely to be multimedia related, to try and take advantage of, just the broadening bandwidth, the broader kinds of content that are there. The big project for the blog for the past couple of years has been improving the substance of what it is that we write, principally by getting better and better people to write. For years and years, we had the incredible good fortune that we had our students at Harvard and Stanford available to write analyses of the cases. And they worked really hard at it, and they did as well as students possibly could. But now we're in a position where we have really leading experts in the field doing the writing because of the prominence of the blog. And so now, the Harvard Law Review, which has 2,000 subscribers, we have, 50,000 people on our slowest day who are committed to taking the content of the blog. And, on the healthcare day, we had 2 million unique readers. And I think that a lot of people who are potential authors kind of recognize the blog now. And we just, we're very lucky in the kinds of people that we're able to get to write for us. Well, we don't really have a target audience as such, and that is, we don't have a vision for the kind of person that we're trying to reach. We recognize that for a long time, the principal people who were reading us were lawyers. Those are the folks who are most naturally fascinated in or have a utility for what's going into and coming out of the Supreme Court. But we've also recognized that as the readership of the blog has grown, we have a lot of people who have, a high school education. And so we've built out, for example, this plain English feature where we'll take all of the major decisions and we'll write them up at length in rhetoric that, an ordinary person can understand without a lot of the legal jargon. And in all of our write-ups, we have a plain English description at the end. So we're trying to accommodate the broadening readership of the blog. And we just view the blog as a public service. It doesn't have an agenda. It's not trying to impress any particular set of people anymore. It's not a business development tool for the law firm. And we just try and accommodate the kinds of folks who are becoming interested in the blog. Sure. Well, we actually are able to study our readership. One of the more formal ways we do that is through user surveys, but we can track all of our inbound readers unless someone takes the highly unusual step of hiding where they're coming from. And the Supreme Court doesn't hide itself. It has the IP address. Supreme Court of the United States is the domain that it is associated with the IP address. And we're able to see, hundreds and hundreds to thousands of hits coming in from them on any given day. And we know from our former students who are clerks, from just casual conversation with the justices, that the court is very conscious of the blog, and a lot of people inside the building read the blog. That doesn't mean that they think particularly highly of the blog or anything like that. Certainly, I would never say that I think the blog has influenced anything that the court has done. But, if you're an important institution and there is one website devoted to following everything that you do, it's not surprising that you're going to read it. And I was concerned that the justices and their law clerks would come to believe that we were writing effectively to them. So that if we were so back in the day, for example, if we filed a cert petition, then we would write on the blog, we filed this really interesting cert petition, it's about this, that, or that question, here's the reason the court might take the case. That was never intended for the court as an audience, but the court doesn't know that and could misunderstand it. And so it became very important to cut all that out, because if the justices don't trust you, then you're not being an effective advocate. The other thing that happens is that because other people realize, or at least perceive, that the blog has an audience inside the building, people will try and use the blog to affect the justices. So constantly we're getting approached by people asking us to write about their cases, highlight their cases, cover cases in a particular way as part of their agenda for influencing the justices. And so we're incredibly resistant to that, both because we think it's improper and because we are just, we don't want the court to look at us in that way. A kind of prototypical illustration is there was a case last term on the merits at the court where the parties were trying to get, one of the parties was trying to get a set of documents in front of the court, and was trying to lodge the documents in the court, but was unsuccessful in doing that. And so they couldn't get them in front of the justices and their law clerks in the ordinary process. And we got heavily lobbied to publish a story about the documents. And they were very interesting. And so it presented a really genuine journalistic dilemma about what to do, because it was apparent to me that a real part of their agenda was not because they wanted the documents published for the sake of publishing them in their interest, because they wanted a backdoor into the court. And we resolved that by not publishing them. But it was a puzzle to work through. Well, at this point, balancing our journalistic and lawyer roles is kind of the daily thing that concerns me the most, and that is I really want the blog to be a journalistic entity. And the lawyer piece of it is actually removing the relationship to the law firm and making sure that the blog can function purely journalistically as much as possible. The long-term dilemma and challenge that the blog faces is that the Supreme Court, though it uses the blog a lot, it refers a huge number of people to the blog, it relies very heavily on it. It's much easier for the law clerks to call up the briefs through the blog than going through the clerk's office to get hard copies. The court doesn't recognize the blog as a journalistic institution and will not grant the blog a press pass. And so at the same time, they're not trying to stop us from covering the court. It's just a question of what you do with credentialing of blogs. It's something the court moves and changes very slowly. It hasn't figured out exactly what it wants to do in the situation. It relies on the Senate gallery and the White House credentialing process to make decisions. So we are nonetheless saved for the moment by the fact that the court still appreciates and respects and values the blog, and so it has credentialed our reporter, Lyle Denniston, as a result of the work that he does for WBUR, which is the NPR affiliate in Boston, and he does interviews with them and helps them out. And so that's the balance that the court has done. It tries to give us access to press-related materials through our reporter, Lyle Denniston. Now, Lyle is 82, And so at some point he's going to stop doing this, though he's going, 200 miles an hour and does incredible work. At some point he's going to decide he's done with it, and what will happen to us then is the long-term dilemma of the blog. Well, interestingly, while the media as a whole is evolving considerably, all that's really happening at the Supreme Court is that the media is imploding, because the Supreme Court is a sufficiently specialized place that it's very difficult for new media to get traction there, because it requires a certain amount of expertise and experience that can be very expensive to develop in terms of lawyering and time and that sort of thing. And so what you have is a situation where the Supreme Court has a traditional press corps of the major newspapers, the major television networks, cable networks, and the like, all of which are retrenching across the board. And it's very easy to retrench with respect to the Supreme Court and say, okay, we're going to cover the Supreme Court with the same person who's covering the Department of Justice. We're not going to have a devoted Supreme Court correspondent. When we think the court's going to do something really interesting, an argument in the healthcare case, then we'll pay more attention to it. But the level of coverage in the media is pulling back because there isn't a corresponding increase in new media. There's an increase in interest in the court, but there aren't other blogs emerging, other Usenets. There's not another body of people that is. It's not just a question of serving as some sort of intermediary to the court, but just a focused expertise on the court, other than SCOTUSblog. And SCOTUSblog now has such a first mover advantage. The amount of money that I have put into it and that I put into it now costs about $400,000 a year to run. Is just a little bit hard for other folks to put into it. Now, you can start a blog for nothing, and if somebody, and there have been other Supreme Court blogs that have kind of started up, but they quickly die because people have day jobs, they have other things that they need to do, and there isn't an angle to make money at it. It's just it has to be a labor of love, and you have to find an appropriate sponsor. We're very fortunate in our sponsorship from Bloomberg Law, which has a legal information service that it's trying to highlight. So it's a very nice fit for us. The court's own website, as you say, is now out there. It occasionally has very significant glitches. For example, taking 30 minutes to publish the opinion in the healthcare case was a significant thing. But they generally make the transcripts of the argument available very quickly after, which is a new thing. The oral argument audio is available the same week, which is a new thing. The opinions are almost always available almost instantaneously, which is a new thing. But what you don't have is then the ability to take that. The court doesn't make any effort, and understandably doesn't make any effort, to take that raw set of materials and convert them into something that people can more easily consume. I take the opinion and take it into 2 pages and really explain what it is that's happening. And then the court kind of changes so slowly that it is a long way away still, I think, from anything like televising the proceedings or consistently releasing the audio of the oral arguments and the decision hand-downs immediately. I'm a big proponent of the televising of the arguments and the decision hand-downs when they announce the rulings. I think that the court has legitimate concerns about what it would do to the proceedings. I don't think it would change things a lot. I do think it would reduce the anonymity of those of them who want to remain more anonymous. Some of them are out doing book tours, and so they're not trying to remain anonymous. But on the whole, I just think that's too bad. Even if every public seat were occupied by only one distinct person for every argument during the term, 10,000 people at most could come see the Supreme Court every year, assuming that they could afford to do it. And it's really expensive to travel to Washington, D.C. And so it's incredibly hard for Americans, if there are 300 million people or so in the country, to be able to see their Supreme Court in operation. And I think it's their right to see it. And the justices believe that their work product speaks for itself, and that's true, but there are other parts of the process that are public. And if the court's going to have a public hearing and a public decision time, I don't think that, given the evolution of technology, it's fair to say that only those people who can manage to be in the courtroom get to see it. So I think eventually that view will win out, but the court really treasures the fact that it changes slowly. It doesn't overreact to situations, and so we're probably at least 20 solid years before the court does that. Well, I think you have to distinguish constitutional principles from constitutional rights. If you were to say, is there a First Amendment right of either Americans to see by television or the media to publish by video the proceedings of the Supreme Court, I think the answer is clearly no. That's not a proceeding. The First Amendment requires that the proceedings be open, but not that they be electronically distributed. On the other hand, if you say, all right, let's not make a federal case out of everything, let's just talk about what's most consistent with the Constitution and the things that we value very highly, I do think the First Amendment points in the direction of saying this is something that the court ought to do, that letting people see the judiciary and the highest court in particular in operation and what it's doing and how it's behaving in a very important part of the process. When you've already decided it should be public, it obviously doesn't extend to the private deliberations of the justices, but the court is a public place, that the better view is that the Constitution, it's more consistent with the Constitution to publicize the proceedings. Now, there's the separate question of whether the Constitution permits Congress to pass a law requiring the Supreme Court to televise its proceedings. This is a difficult and unresolved question. My view, and I've testified about this, is that the Constitution does permit it. It's like the Congress passes the law about when the Supreme Court's term starts and stops, and Congress can set the number of justices even. It actually can be more involved in the operation of the court than people realize. But I just think it would be much better if Congress didn't pass the law, just because it's best not for one branch to intrude on the operations of the other. But a couple more cases like the healthcare case and continued resistance from the Supreme Court, and it could well come to a head. Well, I think that the court does have an expectation that the citizenry will, in a kind of civic sense, really make an effort to understand what it is the court's doing. And that's increasingly important in an era of, cable news kind of spinning what it is and the political parties spinning what the court is doing as itself partisan. The court is in a very difficult spot because it doesn't have, unlike the White House and candidates and that sort of thing, it doesn't have an active press effort. And there are very few people who are invested in the idea of just protecting the court as an institution, because the court's inevitably going to disappoint almost everybody. It's going to do things that anger almost everyone, and at that point, people are going to want to criticize. And so the difficulty is that when the court does something with which you agree, that's only because the court got it right. And when the court does something with which you disagree, then that's because they're a bunch of hacks, not that you are wrong. And so the court's kind of public reputation is a bit of a one-way ratchet in the wrong direction. And in an era in which media participate in tearing institutions down rather than building them up, the court is very exposed. Now, it is, I think, wrong for the court to believe, to the extent it does, that this could be resolved by people just reading the opinions more closely and not believing the spin. Because, when you're a justice of the Supreme Court, it may be possible to lose sight of the fact of how technical these questions are and the level of rhetoric that's involved. And then the healthcare opinion is almost 200 pages long, right? And the idea that an ordinary American, though it affects them tremendously, will actually go and read and understand it is inaccurate. And so having a good set of intermediaries who can help with that process, who can make the Supreme Court more accessible, who are devoted to defending the institution even if you don't agree with a particular decision, I think is important, and is one of the principal roles that the blog plays. And that is, the court does lots of things that I don't agree with, but we still have, and just to give an example, I second chaired Bush versus Gore for Al Gore. But we have a basic faith in the place and view ourselves as kind of specially capable of helping people understand what the court has done and make their own judgments, not let us tell them what they should think about the court's decisions. And I nonetheless think that if the court were to televise its proceedings, faith in the court would go up, not down, because there's this constant barrage of claims that the court is, a bunch of Democratic appointees going to the left and Republican appointees going to the right. And if the public, we're a very visual culture. I don't know if this piece will be interesting to people, what I have to say, but to the extent it does, it is more interesting to watch it than to read it, even though the information being conveyed is just a set of words, not me juggling. And for people to be able to watch the court's arguments, which lots of times are snooze fests, but to appreciate the seriousness with which all of them take the job, the balance that they each try and bring, the hard time that they give to everybody, would, I think, combat the kind of partisan media-driven impression that the justices are not taking their job in coming at it in a truly judicial capacity. There are two principal pieces to the NFIB versus Sebelius decision. One is about the individual mandate, and one is about the expansion of Medicaid. And on the individual mandate, which is the requirement that by 2014 most Americans have health insurance, the Supreme Court upheld that provision, even though the provision was always kind of misunderstood. The provision, as it was enacted by Congress, was never truly a mandate, in the sense that by not buying health insurance, you would be breaking the law. Instead, the provision always said you will have health insurance, and if you're a covered person, if you don't, then you're going to have to pay a tax. And what the Supreme Court said is that structure, which is essentially a tax for failing to do something, is constitutional. They said that 5-4, with the 4 members of the court's left, joined by Chief Justice Roberts, who wrote the opinion. The court, by another 5-4 majority, Chief Justice Roberts and the court's more conservative members, held that the individual mandate couldn't be sustained as a regulation of interstate commerce, which is Congress's principal regulatory authority and power under the Constitution. They concluded that the Constitution, when it allows Congress to regulate commerce, doesn't allow Congress to require the creation of commerce. And that was what would be required by an individual mandate. And that is, you would be required to buy health insurance. They weren't regulating the health insurance you were purchasing. But the bottom line was that this structure of buy health insurance or pay a tax was upheld. So that's the first piece of the Supreme Court's decision. There isn't a big practical difference that comes from the fact that the court upheld the individual mandate provision under the taxing power and refused to uphold it under the commerce power. It seems odd that it would not be authorized under one provision of the Constitution, but it would be under another. The reason is that the Supreme Court wasn't looking at this as a question of, did it violate individual rights? So we have a Fourth Amendment that protects against unreasonable searches and seizures, for example. And no matter what power Congress might use to enact a law, whether under the commerce power or the taxing power, if it violates individual rights, then it's invalid. What was going on here was that the government was looking for some basis to justify the adoption of the law. And so the Supreme Court looked at one basis, the principal one that was offered, the Commerce Clause, and said that doesn't work. You can't create commerce under that constitutional power of Congress's. But the court said, yes, under the taxing power, Congress has an almost plenary authority. It can tax basically almost no matter what it wants to do. It can't adopt penalties under the taxing power, but it can adopt taxes, and it can adopt taxes that are intended to influence personal behavior. And here they've adopted a tax that's intended to influence you to buy health care. And it's kind of an argument that only lawyers could love, and that is that this one box doesn't work, but the lawyers found another box under which it could be sustained. So the upshot is that the individual mandate survives. Now, there is one practical consequence to rejecting one theory of the Commerce Clause and accepting another, the taxing power, and that it really focuses people for the first time on this fact that you can refuse to buy the health insurance. And particularly in the early years, the tax is not very much. It's only $60 for most people right out of the box, I think. And then it focuses people on another provision that says that if you refuse even to pay the tax, you can't go to jail for tax evasion. The IRS can garnish a tax rebate of yours. They can make harassing phone calls. But the government's ability to enforce the tax is actually very limited. And so it is possible that there will be people, supporters of the Tea Party, for example, who will, as a matter of principle, just refuse to pay the tax. Will refuse to buy the health insurance and may even refuse to pay the tax. So there's also the second part of the case, which is really not one that people expected there to be much action in, and it turns out there was. This is the very significant expansion of Medicaid eligibility under the Affordable Care Act, and Congress provided that most of the costs, initially all of the costs, for the expansion of the Medicaid rolls would be paid for by the federal government. But Congress had said to the states, well, you don't have to take this Medicaid money, but if you decide not to, then we can take away not just this Medicaid money, but all your Medicaid money. And the Supreme Court really, for the first time, and it did this in the Sebelius case by a 7-2 majority, said that's too much extortion to try and make the states change their Medicaid eligibility that much under the threat of losing all of their Medicaid money. And so this has to be interpreted as essentially an option, that the states have the ability to make a decision about this pool of money without endangering all of the money. And what that means is probably not a huge amount. There may be some states like Texas that have very conservative governors that may decide to turn down the new money as a matter of principle and not expand their Medicaid rolls. But almost every state, they're just not going to turn down billions of dollars to provide health care to their citizenry. So there are going to be some states perhaps that will not take the new Medicaid funding. The big impact of that decision is probably going to be felt in other areas of the law, because Congress does this all the time. It pulls back on the purse strings. It offers you money, but it makes it contingent on doing all kinds of things. The classic example really is highway funding. If you don't make your drinking age this, if you don't make your maximum speed limit that, there are numerous provisions in the U.S. Code where Congress threatens the states with yanking money out from underneath them if they don't comply with congressional directives, and you can probably expect to see a lot more lawsuits about that. So there have been all kinds of rumors and allegations and supposed leaks from the court about what happened in the voting in the healthcare case, focused almost entirely on the idea that the Chief Justice had voted to invalidate the mandate and changed his mind, and the claim that he did so out of fear for the court's reputation. At the threshold, you have to be incredibly doubtful about the accuracy of this. These are all completely unsourced things from people who have agendas, who are trying to spin things in their own favor. And when the court, again, is just not in a position to respond because it never comments on things like this. If you were to ask me kind of what I bet happened here, is I expect you can tell a little bit from the opinion assignments, and so we know that the Chief Justice almost certainly had the majority from the very beginning. And my guess is that he, coming out of the box, out of the oral argument, was confident that he didn't think the statute could be upheld under the Commerce Clause. He was confident in the Medicaid ruling, and he was struggling with what to do about the taxing authority. And that both the left and the right thought that they had a very good chance of him coming down on their side. And he eventually resolved that in favor of upholding the statute in the course of the writing process. And that conservatives inside the court were apoplectic about that. And they have spun it as the chief not doing that in a kind of judicial capacity, but in a political capacity of trying to protect the court's reputation. Now, that doesn't really make a lot of sense in the sense that it's not, the Affordable Care Act wasn't the world's most popular statute. It wasn't that Americans were clamoring for it to be upheld. And so it seems very unlikely. I think that the chief is certainly aware of the consequence of the decision in terms of it I think builds the court's reputation as a nonpartisan institution, but I don't think that would have driven his decision. I think he's an incredibly serious guy, has that reputation, and I think that the whole set of rumors really reflects very poorly on those who have participated in the leaks, and it wouldn't be surprising if they diminished themselves in his eyes and the eyes of others, because it's so irresponsible and it's kind of a wild accusation. It seems like that the leaking of that claim started a couple of months before the decision itself, where someone or some people were trying to put word out that the chief was wobbly and that he might vote to uphold it for reasons of the court's reputation. And so that there was by at least one person, a real concerted effort to kind of pressure him internally and externally, which is very, very unfortunate and unseemly. I do think that it's conservatives who are upset, some subset of conservatives who are upset with the chief for the moment, but that's going to pass, I think, very quickly. He is a very solidly conservative justice, if you just look at the pattern of his votes and the time there, and nothing is fundamentally different about that. And kind of folks on the left, liberals, progressives, who are excited about his decision are going to fall out of love with him just as quickly as they've fallen in love with him, because he is who he is. And I think that one consequence of this, hopefully, was that there'll be less leaking, but conceivably a consequence of it will be that there's more, because this happened No one seems to have been burned by it. And a new culture could emerge of trying to influence the court from leaks from within, which would, I think, be very unfortunate. Maybe. Right, so you can look at the decision in the fashion of saying we're going to finally put some brakes on Congress's commerce power, which has really been the principal tool it's used for the expansion of the entire regulatory state. And we're not going to completely hobble Congress because it can do things through taxation, but it's going to be held really accountable for doing that because there's such resistance to things labeled taxes. And so Marbury versus Madison is a very similar situation where by kind of varying one power and disclaiming another, actually the court produced a very particular outcome, a much more subtle, sophisticated way without seeming to claim a lot of power for itself. The Supreme Court ended up with judicial review. The difficulty with that reading of this decision, I think, is that the limitation on the commerce power that's articulated in the decision is not really a very significant one. The whole point of the plaintiffs, the states, the National Federation of Independent Businesses is that Congress had never done this before. It had never ordered the creation of commerce. And there really isn't any reason to expect that Congress was on the brink of doing that in other contexts. When the economy really cratered, they didn't order people to buy cars. It was a very unusual provision. Now, if the court's Commerce Clause holding pretends a rebirth in a line of cases that says we're serious about, for the first time in a century, paying attention to limits on the commerce power, if this is the first of many decisions, well, then it will be very meaningful. When Chief Justice Rehnquist passed away and Sandra Day O'Connor left the court, the principal movers behind recognizing limits on federal power kind of left the court. And we haven't really seen previous indications that their replacements in Chief Justice Roberts and Sam Alito really were going to rework the law in this area and rebalance power between the states and the federal government in limiting the Commerce Clause. But if that's not true, if they are now quite serious about that, then that will be the lasting legacy of this decision, together with the limitation on Congress's spending power, the ability to yank back the Medicaid money, and what that will mean in other contexts. But for the moment, the Commerce Clause decision really is a one-off, and I don't read it as more than a one-off because it's not part of a larger body of decisions over the past 5 years where a majority of the Supreme Court has said, we are serious, Congress, you're going too far, you're trying to do too much under this Commerce Clause power, we're going to put the brakes on you. Well, the first 8 minutes of coverage when it came to the cable news side of things of the decision was obviously really unfortunate. CNN in particular is, apoplectic about its error. Fox News is much more comfortable with kind of, here's what we thought at the time, and you're experiencing it with us. And it's a mistake that should not have happened, and I don't think will happen again for a while. It's akin to what happened with the 2000 election, who wins, switching back and forth. And it was an avoidable mistake, and most of the media did avoid the mistake. The first 4 wire services got it exactly right, and it was possible to get right if you were just a little bit more patient than they were. Sure. Well, there was a couple of things happened in reporting the decision. There was an expectation that it was going to be struck down. And so that when someone said it's been invalidated, that met with the expectation of the producers and the people in the control room. Second, the cable news networks were so tightly wound into their social media and web properties, particularly CNN, and they had kind of bunched up at the gate all of this reaction that they wanted to put out there because they came at it from a political angle rather than a question of healthcare being available, because that was kind of just the more exciting take in the middle of a presidential campaign on it. And the only thing they really did to pause to make sure they had it right, besides asking their people who had copies of the opinion, are you sure, was to look up and see each other reporting the same thing. And at that point, then they had all of this stuff that they wanted to say, and in a really breathless kind of way, and oddly breathless. I mean, everybody knew the decision was going to come down at 10 o'clock that morning. The provision of the law wouldn't take effect for 2 more years, and the election is not until November. And so it's kind of strange that that they would burst out of the starting gate in that way. But there was, those things did conspire to produce a situation where CNN in particular had a little bit of a hard time walking it back over the course of those 8 minutes. More broadly, in terms of the coverage of the decision, I'm perfectly comfortable with people kind of making of it what they will, and there's a self-referential quality to the idea of this has huge political implications, because the more the media says it has huge political implications, that's actually in large part what's driving its being consequential politically, and that is all the yammering about it has turned it from, and the individual mandate is obviously originally a Republican idea, and it has, through a bunch of political commentary, become viewed as anathema to individual liberty by conservative Republicans. But nonetheless, it is what it is, and a very important part of the implications of the decision were political. And that's very accessible to people. Ordinary Americans are pretty used to thinking about those things like that in those terms, whereas legal doctrine like the Commerce Clause and the taxing power kind of just flies over everybody's head, and the implications for healthcare markets are relatively complicated. And so it doesn't surprise me or trouble me that people would look at it that way. I actually like the fact that a lot more people pay attention to the Supreme Court for whatever reason, because the court is an underappreciated institution, not undervalued. Whether it's good or bad, people just don't watch it enough. Yeah, I think so. I think that the fact that more Americans engaged the Supreme Court is civically good, because the court is doing some good things and some bad things, and it's a lasting legacy of every president, not every, but every president who does get to make the appointments, and the public ought to be more aware of what effect the judiciary has on them, for good or bad. You may love things the Supreme Court's doing. You may despise them, but it's very hard to make the argument that the Supreme Court is inconsequential. Well, the part of the difficulty is that mainstream media is really driving for eyeballs and attention more than it's driving exclusively for substance and accuracy and balance in things that can sometimes be very boring. So one of the things that you have is that the institutional concerns that seem to in part drive the healthcare decision. So putting entirely to the side the idea that the Chief Justice was concerned about the reputation of the institution, which is difficult to figure out given the uncertain popularity of the law. But the idea of institutional competence and responsibility, the Chief Justice says, look, our job is not to strike down a law every time we can find an excuse to do it. It's to find a way to uphold the law if there is a way of doing it under the Constitution. That's our job. We're the last resort, not the first resort. That gets spun a lot as by people who don't like the decision as being a cop-out in the same way that a lot of more conservative decisions get attacked by the liberals as being driven by partisan interests of another kind. But these institutional concerns exist across a huge body of the court's jurisprudence. It balances them in different ways in different cases so that the court's conservatives believe very strongly in the right to engage in campaign spending, for example. And you get decisions like Citizens United because they believe that's a core First Amendment right. And in that situation, they don't hesitate to override what seem to be very well-studied judgments by Congress about the effect of spending on confidence in the electoral system. And there's a good chance the court's going to strike down Section 5 of the Voting Rights Act this term, affirmative action programs. It's not that the court as a whole or the court's conservatives really do tend to just say, I'm only going to strike something down if I absolutely have to. At the same time, the court does often show a recognition of limits on its institutional competence when it comes to things like regulation of jails, when it comes to strip searches in the past term. There are a lot of different times when they say, we're not the best people to make this decision. There are other people who are better at this for us at making this kind of judgment. You don't see, however, from the current Supreme Court a vision of that extends across bodies of law. Sometimes they are super confident and very willing to intervene, and other times they seem more willing to take a back seat, and I would be hard-pressed to draw a straight line between those points. But in terms of media coverage, the latter cases where the court is kind of saying, okay, we're going to defer to the jailers or to state legislators here, it's just not very interesting. When the court doesn't do something and says, we're going to let this be, somebody else has got this in hand, it's not our responsibility, it's just not very sexy or controversial. And as a consequence, millions of people are not going to tune in to hear the fight about it. It can be turned into a fight by, as in the healthcare case, turning into allegations of the Chief Justice just trying to, for the wrong reasons, protect his institutional legitimacy and his own popularity. But by and large, people are just sort of like, that's dull. No, I think that if anything, the court is pulling back on the limits that it's imposing, not because of a sense of lessened institutional competence, but we are still in the midst of a counter-revolution from the Warren Court era. And so while it's true that in the Jones case about GPS, you see an articulation of possible limits on the use of technology, if one were to just track the arc of Fourth Amendment law and the scope of reasonable expectation of privacy, defendants are losing those cases much more than they're winning them. They're winning some car stop cases, Arizona versus Gant, but in the main, the direction is in terms of giving the police greater flexibility to conduct searches and seizures, not lessened authority. And that's true across an array of rights that the more liberal Warren Court recognized that are being undone. Abortion is an example, separation of church-state is an example. You are seeing a resurgence of limits generally in terms of what might be called conservative civil liberties, the Second Amendment right to bear arms, conceivably the Takings Clause, religious liberties, and some limitations on congressional power. And so I just think that with some exceptions like the GPS case, by and large, the kinds of assertions of rights that the court is recognizing and accepting are just of a different kind of right. And it's peeling back and overruling and limiting decisions that had recognized other rights. I don't think there is a broader flexing of muscle going on. It's, in campaign finance, that's true because the court really believes that's a core part of First Amendment expression. It's not because across the board the court feels more empowered. I think for this presidential election, like most in the past, at least since the Nixon years, the court isn't going to be very important to the broader electorate. The economy just eats up all the oxygen in the room. It matters as a motivator, get out the vote point for each party's base. The idea that we need a more conservative Supreme Court, that we probably have the most conservative Supreme Court in American history, for Tea Party supporters is a palpable and important thing that would cause them to feel, among other things, that it's critical to get out and vote for Mitt Romney. The idea that we are a vote away from Roe versus Wade being overruled or interred into meaninglessness for the left is a very significant thing for people who are already focused on the court and think of it as an issue. In terms of changing people's minds about who they will vote for, it should be a real issue. But there's just only so much attention that the electorate can and will pay, and people are worried about feeding their families and about jobs, and that's immediate and incredibly consequential. And I just don't see the Supreme Court breaking through that. If this were the 2008 election rather than the 2012 election, it would probably be very similar because we were starting into the real depths of the financial crisis. 2004, 2016, the coincidence of healthcare, which is the case that has generated the longest sustained interest in the Supreme Court in 80 years. And it really could have been an issue. But this is an election where I think there's just, it's not going to be possible to get people to think about much other than the economy unless they're already committed to one side or the other. Well, doing things in a way, the media doing things like this that are interesting, hopefully, and engaging and are serious and longer form. Justice O'Connor has really been the person who's been very focused on the broader project of civic education and returning to that as a real value. Adapting to the public to some extent in the shorter periods of time that it's willing to give to any issue and trying to make coverage of the court interesting but yet substantive. Trying to make people understand the lasting significance of the presidential election and the appointments, the way that the law really does evolve. A lot of people, I think the Constitution is this thing, and not only should it be read the same way all the time through history, but that's actually how it has worked. But in fact, the phrases unreasonable search and seizure, due process, the notion of freedom of religion and expression have meant a lot of different things over a long time. And so the Supreme Court's ability to change the law and the basic framework for governance is tremendous. I really regret that the amount of coverage in the Supreme Court is going down rather than at least holding steady or going up. And so it's also going to be a resource allocation question. One thing that fascinates me is, will the public's interest in the Supreme Court in the wake of the healthcare decision be sustained? Though, we're a month out from the decision as this is being interviewed, and our level of readership, which was 2 million unique readers with 6 million visits on the healthcare decision, has already returned to its pre-healthcare levels. Now, it's the summer and the Supreme Court's not doing anything, so it's not a surprise. But people have already, to some extent, really moved on. And the next test will be when they hear the affirmative action case in October, when they hear gay marriage, when they hear the challenges to the constitutionality of the Voting Rights Act, as they almost certainly will Americans be back? Or will they just, are they now engaged in the question of the Supreme Court? Is there a lasting legacy or not? After Bush versus Gore, there really wasn't. But, might healthcare be different?